Hello and welcome to another edition of Inside Family Court. My guest today is Judge Bowles of the Jefferson County Family Court. Judge Bowles was the co-author of the domestic violence legislation, and today's topic is domestic violence. Unlike previous shows, today we're actually going to show you a mock trial, and we'll get to that in just a moment. Judge Bowles, thanks for being with me again today.
You're welcome. Thank you.
Judge, how does the legislature define domestic violence?
Bill, domestic violence is defined as any act of physical violence, physical injury, sexual assault, or any conduct that puts someone in fear of physical violence or sexual assault.
Who has got the right under the law to come in and ask for protection from domestic violence?
The Domestic Violence Act is an effort to provide protection within a family unit, and so it's available to family members, whether it be through marriage or through blood. It's available also to unmarried couples who have children in common or who have at some time in their relationship lived together, obviously ex-spouses, children of those relationships.
Is or can an act of domestic violence be a separate crime?
Yes. In fact, the act of violence is often a criminal offense. The request for a protection order is to prevent future acts of violence on that individual.
Really a civil remedy versus a criminal.
It is. If you think about a single act of assault, the protection order would be an attempt to keep that person from hurting the victim in the future. The criminal act would be to punish that person for the incident that's already occurred, with our criminal system being a punitive system, but the civil protection order would be to provide some safety for that victim in the future from further acts of violence.
A person takes out a request for an emergency protective order, ultimately evolves into a domestic violence order. Does that preclude them from pursuing the criminal remedy?
No, it doesn't. In fact, when police are often called to a scene of domestic violence, they will arrest the perpetrator and suggest to that victim to go file for a protection order, knowing that that perpetrator is going to get out of jail and that some protection needs to be in place.
As a very practical matter, where does a person go, let's say from 9 to 5 or 8:30 to 5 during the week to get an emergency protective order?
We have an office within the Judicial Center here where victims of domestic violence come. It's on the first floor of the Judicial Center, 700 West Jefferson Street.
This is the new courthouse, the big tall one.
It is the new Judicial Center, the 10-story building, and they come here and there are individuals from the clerk's office who assist them in preparing their petition request for protection.
What about after hours, after 5 during the week or sometimes during the weekend?
Jefferson County is piloting a new project called a Victim Intake Center, where victims actually go to a central location in the Hall of Justice, and that's the building immediately east of the Judicial Center, the old courthouse, and there is a intake office where they can apply both for the protection order or for any criminal warrants or remedies in one location in the Hall of Justice.
So the bottom line is there's never a time when a person cannot get this kind of assistance if they need it.
That's correct. EPOs, emergency protective orders, are available on a 24-hour basis. If they come in at 2 in the morning on a Sunday morning, there's a clerk there to take that petition from them, a judge is on call, and they can leave here if they qualify with a protection order.
Tell us just briefly the difference between the emergency protective order that you just mentioned and a domestic violence order.
Okay. The emergency protection order is the initial order that's entered at the time the victim comes to the courthouse and applies for the protection, assuming that there is a basis legally to issue the protection.
Sure.
That's only good for 2 weeks. There has to be a full hearing afforded the respondent or the alleged perpetrator, and at the full hearing, then the court makes a determination after hearing both sides if there's a basis to enter the extended order. A domestic violence order is good for 3 years and can be extended up to 3 years, additional increments.
All right. Thank you, Judge. When we come back from our commercial, let's take a look at this hearing.
Okay, thank you.
Okay. What you're about to see is a mock or pretend domestic violence hearing. This takes place actually in the courtroom using the facilities of the Jefferson County Family Court. The participants are all individuals who are employed by the court system. This is a pretend hearing, but will give you a good idea of what's going to happen during your domestic violence hearing. Let's go ahead and run the hearing tape now.
We're here today for a domestic violence hearing. Ms. Smith, you have filed a request for a protection order. As part of your request for protection, you signed an affidavit that states as follows, that you and Mr. Jones have a child in common, that you waited to come down here because you were hoping it wouldn't have to come to this, that Mr. Jones would leave. He has told you that the only way he would leave is if you got an EPO. You state that he has threatened to get you, whether it was that day or the next morning. He is repeatedly telling you that he is going to kill you. You state that about a week before this petition was filed, you were at your mom's house, that he came in accusing you of having a boyfriend, that he mugged you in your face, that he pulled your hair. You state that he is verbally abusive to you, that you are frightened of him, that he isn't working, he's not contributing to any of the household bills, that you're paying all of them, but he refuses to leave. He has threatened to go to your 2-year-old daughter's daycare and take her. He has also told you he's going to show up at your work and get you fired. Are these statements true?
Yes.
And do you adopt these statements as your testimony today? Has there been prior incidents of violence in your relationship before the incident at your mother's?
There have, but he hasn't ever really hurt me.
And what kind of physical contact has there been in the past when he was angry?
Just pushing and shoving, and he pulls my hair a lot, that kind of thing.
And the statement that he was going to kill you, when did he make that statement?
It was a couple days ago, I guess. He's always saying stuff like that. He just said that he was going to kill me, and he was accusing me of having a boyfriend and all that kind of thing.
Was he angry when he made that statement to you?
Yes, he was.
And were you frightened by that statement?
Very much so.
Was the child present at the time of the incident where there was a physical altercation?
She was sleeping.
Is Mr. Jones under the influence of alcohol or drugs at any time that these incidents are happening?
No.
Is there a history of alcohol or drug use?
No.
Okay. Mr. Jones, do you have any statements you'd like to make?
Yes, I would, Judge. I'm not a violent person. No, may have said some things. Those are, just allegations that she made towards me. I'm not a violent person at all. I've never hurt her. I've never put my finger on her, hands on her.
Did you tell Ms. Smith that you were going to kill her?
Well, I was mad that night. When you get mad, sometimes you say things you don't mean. I may have said it, but I really didn't mean it.
Why would you tell somebody you were going to kill them?
Well, I didn't mean, the words came out wrong. She wouldn't let me see my daughter. Things have just gotten out of hand. Our relationship is no longer together. It just really upset me.
And you were angry?
Yes, I was.
Do you understand, Mr. Jones, when you make those kind of statements out of anger, that those statements can be frightening to someone who knows that you have the ability to hurt them, and that that's the basis for me to issue a protective order in this case?
Yeah, I know, yes.
Okay. Ms. Smith, this court's making a finding that there have been acts of physical violence or acts of intimidation or threats that would cause you to be in immediate fear of physical violence, and therefore that you're entitled to receive a protection order. Mr. Jones, at this time, I'm ordering that you have no contact or communication with Ms. Smith. You're to stay at all times at least 1,000 feet away from her. Do you understand that?
Yes, I do.
Okay. And are the children, are your children, are they Mr. Jones's children as well?
Yes, we have one daughter.
Okay. And do you intend to continue your relationship with the children, Mr. Jones?
Yes, I do. One thing I'd like to know is how am I going to be able to see my child if there's no contact order?
Well, do you understand that when I issue a protection order for Ms. Smith, that doesn't prohibit you from visitation with your children? It just means that you're not going to exchange these children with Ms. Smith. There is a visitation exchange center located in the Hall of Justice. There's also a visitation center, and that we can either utilize either one of those resources, or you all can select a third party for the exchange. But the purpose of the third party exchange is that there would be no further acts of violence that would occur in the presence of the children. I'm also ordering that you complete a domestic violence treatment program. There are a number of court-approved providers. Your attendance there will be monitored by the Corrections Department, the Court Monitoring Center. You're to report back here to this court in 8 weeks with verification that you have been assessed and that you're attending that treatment. Do you understand?
Yes, I do. I have a question.
Yes.
What about my belongings in the house? How can I retrieve those?
Okay, you are under a no contact order, so you are not to return to that residence. If you have personal effects that you need to retrieve from the residence, you need to designate a third party. Ms. Smith, do you understand that you have to release those personal effects to some third party that Mr. Jones designates?
Yes, sir.
Okay.
I have another
Mr.
question.
Yes.
Say I'm at a restaurant or a mall or a bar, and I'm there and she shows up. What am I to do?
Mr. Jones, I have made a finding of domestic violence in this case. You are under an order to not go within 1,000 feet of Ms. Smith. If you go into a restaurant and she's there, you need to leave. You're the one under the order. You're the one that would be arrested for violating this order. You need to understand that if you violate this order, it carries up to a year in the county jail. Violation of this domestic violence order is a Class A misdemeanor, and you could serve up to a year in jail and a $500 fine for violating this order. Do you understand that?
Yes, I do.
Ms. Smith, this order will be registered in the law enforcement network system, which is the police radio system that's utilized by police officers throughout this Commonwealth. If you don't physically have your order of protection on you, you can still have the officers access the terms of protection that you've been granted today by their radio systems. In addition to it being registered in the Kentucky information system, it'll also be in the NCIC. Under the Violence Against Women's Act, you'll have full faith and credit protection of this order in all 50 states. If you're in Indiana or any other state and Mr. Jones violates the terms of this order, you need to contact law enforcement in that state. They'll access the terms of this protection through the NCIC system, and Mr. Jones, you would be arrested under that state's law as if you'd violated the order under this state. Do you understand that?
Yes, I do.
Do you own any firearms, Mr. Jones?
No.
It's also a violation of federal law to possess a firearm while this order's in effect. If you're in possession of a firearm while this order's in effect, you could end up serving up to 10 years in a federal penal institution. Do you understand that?
Yes, I do.
Okay. Do you all have any questions regarding any of the terms so far of this order?
No.
Okay. Do you also understand that there'll be a visitation order that's prepared by the court support worker in this case?
Yes.
And that court support worker will meet with you after you leave the courtroom today, and you all will each need to provide her with information regarding your requests for visitation. If you all can't agree on a visitation arrangement, if either party objects to visitation, then you need to let that court support worker know that. In the event that you all can't reach an agreement through the court support worker, then you can come back in and hear the case. Also, as part of the order today, I'm going to order Mr. Jones that you meet with the child support worker from the county attorney's office. Child support will be set based on your respective incomes. That child support worker will utilize the Kentucky guidelines for child support and give me a amount to place in this order. That'll be paid by wage assignment. Again, you will be having no contact with Ms. Smith. That amount would be directly deducted from your income and sent through the state to Ms. Smith. Do you have any questions about that?
No.
All right. Ms. Smith, do you understand that there is a counseling service through the Center for Women and Families.
Yes.
And I would strongly urge you to access a support group or counseling through the Center for Women and Families. You also may want to consider whether your children should be evaluated for counseling. There's a strong correlation between emotional trauma to children who have witnessed domestic violence. And those services are also offered through the shelter. The victim advocate that's here with you today can work through a safety plan. You need to understand that this order of protection will only protect you if you report the violations. If Mr. Jones has any contact with you, you need to call the police. This is the only civil order that the police can enforce. And there's a mandatory statute in this state for the police to enforce a protective order, mandatory arrest. So, Mr. Jones, if you have any type of contact or communication with Ms. Smith and she contacts law enforcement, you will be arrested. Do you understand that?
Yes, I do.
Okay. Do you also understand that if you fail to complete the court-ordered counseling, the Domestic Violence Perpetrator Treatment Program, that you could be brought back before this court on contempt?
Yes, I do.
Okay. Contempt for violation of that portion of the order could carry up to 6 months in the county jail. Do you have any questions about the terms of that order?
No, Judge.
Okay. Ms. Smith, you've also requested temporary custody. Do you have a paternity case that establishes Mr. Jones's paternity to the child?
He signed the birth certificate, but I don't know if that's enough or not.
Okay. You all need to meet with the county attorney's office when they come up for child support and institute paternity actions. Mr. Jones, I need you to either acknowledge on the record today if you know that this is your child for purposes of visitation, or I need you to set up genetic testing through the county attorney's paternity docket. Do you understand that?
So I'll acknowledge on the record I am the father.
Okay. You understand you don't have to make that acknowledgement without counsel, and that you have a right to have genetic testing?
Yes, I do.
Okay. I'll accept your admission today to paternity and let the record reflect that there is an admission by the respondent. Okay. If you all don't have any other questions, then I'm going to release you to meet with the court support worker and the child support worker to establish visitation and child support. And Mr. Jones, I'll see you in about 8 weeks to see how your treatment's going. This order's in effect for 3 years, and any amendments of this order have to come back through this court. Thank you.
Yes.
Judge, as people watch this hearing, I'm sure one of the things they'll notice was that there were no attorneys present. Can an individual bring an attorney to a domestic violence hearing?
Sure. Frequently, both the petitioner or the victim in a domestic violence case or the respondent, the alleged perpetrator in the domestic violence case, are represented by counsel. The proceeding is designed so that it can take place without counsel in the event that people choose not to retain counsel, but certainly it's a legal proceeding and there's often counsel.
Very good. You, during this hearing, laid out some of the remedies or some of the orders that you can issue, but I'd like to take a moment and just kind of recite those again. What relief can an individual who comes and where the court decides, yes, domestic violence has taken place, I'm going to issue this order. What can those orders look like?
That's a good question, Bill. Once I make a finding of domestic violence, the statute allows me to offer several remedies to a victim of domestic violence. In the hearing that we just conducted, that victim was apparently leaving the relationship and wanted no contact or communication. Many victims of domestic violence want to remain in the relationship with the respondent, but they don't want any further acts of violence, no additional physical violence in the relationship. You can get a protective order that protects from further acts of violence or threats of violence in the relationship. So that's one of the remedies that's available.
And if you were to give that remedy, the couple stays together, but there's no further acts of violence, how do you know if that's been violated? What do they do? What do they need to do to...
Well, for any protective order to work, obviously its value is in the enforcement of the order. So when a victim leaves here with a protective order, whether it's to keep the perpetrator from having contact with her or no further violent contact with her or him, the order is only going to be effective if it's enforced. And so it's incumbent on the petitioner to report violations and law enforcement respond to those.
The person who got the order, if it's violated, they need to pick up the phone and make the call.
That's right.
Is that
We've
what you're
all heard the statement of protective order won't stop a bullet. And,
Right.
and while that's true, there's a lot of information out there to tell us that when violations are routinely reported, especially minor violations early in the infancy of the order, that they're more likely to be followed.
Very good. But I think we bring up a point there that is important, and that is, these ultimately you need to be responsible for your own safety.
That's right. That's right. There are, if you noticed in that tape, there was an advocate that was seated at the table with the victim. Our system has advocates both from the Center for Women and Families, Adult Protective Services will appear from the Cabinet for Families and Children, and they all offer advocacy on safety planning. Victim needs to understand that they need to engage in certain protections that are available because they know that perpetrator better than anyone else.
Now, in this hearing, you brought in the county attorney to provide some support for child support and establishment of paternity. Do we have other organizations in our community that provide support for victims and families of domestic violence?
We do. We have several counseling agencies that provide services both for offenders of domestic violence, and they also have counseling and support groups for victims of domestic violence. The Center for Women and Families has housing and shelter for victims and for their children. Again, the Cabinet for Families and Children offers adult protective services workers to work safety plans and connect people with services. So we're very fortunate in that we have a community involved in resources for these people.
And this is relief that the court can either look and say, I'm ordering you, as you did in this, to anger management, or the individual can say, hey, could I, who else can I follow up with?
That's
on
right.
this?
That's right. Often victims are referred to domestic violence victim informational sessions, some of which are conducted here at the courthouse, some at various locations outside the county. So.
Very, very good. In this order that you gave, and I think this is a fairly recent change to the statute, the protection was for 3 years. And my recollection is it used to be a year.
Right.
Was the max.
Right.
Now, what, if any, remedy does a person who's received a domestic violence order have at the end of that 3 years? Is there anything else that can be done, or is that going to have run its course?
Okay. Under the current law, in addition to being able to obtain a 3-year order, that victim can apply to have that order extended. And those extensions can be up to 3 years, and there's no limit on the number of extensions a victim can receive. Sometimes where the violence has been very serious, there may be a perpetrator that's going into prison for 3 or 4, 5, 7 years. So they may need to extend that order beyond, so that when that person's released that they have that protection. Domestic violence orders are one of the few civil orders that can be amended more than 30 days after the judgment or 10 days after
Excellent
the
point.
judgment. And that's another issue that victims need to understand is they may initially elect to stay in that relationship and it may not work out. And they always have the right to come back and ask that that order be amended to receive the no contact or vice versa.
One of the things that I like to talk about is of course we're living on the Ohio River. We've got Indiana. We've got a lot of people moving back and forth. And touch one more time, as you did in the hearing, on enforcement between states.
We have federal legislation called the Violence Against Women's Act. And in that act, there is a provision that provides full faith and credit of all domestic violence orders for all 50 states. And because this is a civil order, there has to be some mechanism for enforcement of that state's order in other states without the filing of a new action, and that's what that federal legislation does. So in Indiana, a Kentucky order would be enforceable just on its face, much like any other state.
The viewing audience may not understand that so are other judgments for money and other things, but there is a fairly involved process when you take a Kentucky judgment and go to Indiana or go to another state
Right.
to get it registered.
Right.
And what
Right.
the federal legislation, if I understand what you have said, is kind of cut through all that.
Right.
And basically a person, as I understand it, can show up in the sheriff's office or the clerk's office of whatever county, of whatever state they're in, show them their order, and there are laws and processes in place to
That's
give it
absolutely
effect.
right. And the neat thing about what has happened on a national level is that there's a registry to collect all of that information. So there's actually a file in the NCIC file system that's national, that I can identify an order from California, I can identify an order from Illinois through a registry that would be accessible in this state.
Wonderful protection.
Right.
Judge, thanks again for being with us
You're
today.
welcome. Thank you.